All right, welcome back to the Law and Crime Network. I'm your host, Bob Bianchi. This is our new show, Law and Crime Report, July 20th, 2020. We have a really sad case here. A New Jersey federal court judge's husband was shot and is in critical condition, and her son, 20 years old, was shot in the heart, from what we're being told, and was actually killed. It is a murder case. Allegedly, an individual posing as a Federal Express employee knocked on the door. It was open, and that's when the crime was committed. So I got two great guests, Kirk Burkhalter, who's always a great person to have on the show, New York law professor, as well as a retired detective. We'll get a lot of experience from him. And my Jersey girl, Linda Kenney Baden, is back with us. She's a host here at the Law and Crime Network and a famed criminal defense attorney and former assistant prosecutor. Welcome to the show, guys. Our first version new show here at the Law and Crime Network.
Thank you.
Linda, let me toss to you first. I believe you have contacts with Judge Salas. I worked with Mark Durst, who was an assistant Essex County prosecutor in the homicide squad and had tried a lot of high-profile cases and now does criminal defense work. Give me your thoughts. I mean, it really hits close to home when something like this happens to people you know.
Well, this is a Sunday at 5:20. This is somebody who really knew the judge was not going to be protected by marshals then, Bob, because as you know, the marshals kind of take them halfway home or take them home after a work day. But the problem is that everybody here could be the target. It could have been the husband who worked in the homicide section, as you know, in Essex County. It could be the son who was a college student, 20 years old at Catholic University. And of course, Judge Esther Salas, who was appointed by President Obama. It could also be her. So the marshals and investigating this, the FBI, have their hands filled. But let me tell you, this is going to go to the ends of the earth till we find out who shot and killed this child. I'll call him a child, his son, a 20-year-old son, and who planned it.
Yeah, Kirk, let's draw on that law enforcement experience as a detective. I mean, right now, they're going to cast a wide net. I agree with Linda Kenney Baden. There will be no resource spared, no federal, state, or local agency that will not be involved in this. And I think that wide net is first, they're going to start looking for motive. They're going to be looking, in my mind, for teams of people. They're going to go out to see who may have had a motive with regard to the husband as a defense attorney, or who was released from jail that he may have put in jail when he's an assistant prosecutor. Of course, they're going to be looking at all the judges' cases. They're going to be looking into the son. They're going to be looking at electronic devices. But they are not going to let their grips go on this one. What do you think are other things that they're going to do investigatively?
Well, the big ticket item here is starting with the judge, of course, and what cases the judge has sat on and adjudicated, and who might have some form of complaint with the judge. It's like you said, it's such a wide net to be cast here. What is interesting is if the judge herself was a target, then why did the shooter stop, right? The shooter, unfortunately, killed the son and neutralized the husband. Why did the shooter stop and not continue on? Did the shooter have reason to believe that no one was in the house? So that may lead law enforcement to tend to believe that someone else was a target, or this person may not have just been seasoned at doing this type of thing. Was this person an actual FedEx employee of some type? How do you get that type of uniform? So as you mentioned, it's just such a wide net here. So many leads to run down to get to the bottom of this. However, I would have to agree with Linda and you that no stone will be left unturned, and the perpetrator here is going to feel the full force of the United States government.
You know, Linda, when I was doing as prosecutor investigative work in homicides, or when I was in the homicide squad, you had to be careful not to pigeonhole yourself into a theory of a case, because it could be, and I'm just throwing it out there, and I say this as a public service announcement, a random, kind of case where people have done this before. Typically, robbery would be involved in it. We don't know any of the facts here right now, but people have to be very, very careful when they open a door. Here up in the county that I was prosecutor in, one of the things that was going on for a while was people posing as florists and people opening the door. Let's do that public service announcement. Even if somebody's in a uniform, if you're not expecting them there or you don't expect a package, you have a right to be able to ask them, who's your supervisor? Give me the number, or you call and you make sure, or don't open the door at all unless you're 100% sure. And this case underscores that fact.
But Bob, this is like a community from what I read, Hidden Lakes. It has a clubhouse. It's not where you normally expect to see this kind of shooting. That's why it had to be a target shooting, in my opinion. Even though remember there was a federal judge a few years back in Chicago. It turns out it was a burglary, a random case. But on this one, hey, there's already theories of conspiracy out there. She was just assigned the Deutsche Bank Epstein case, right? She had other high-profile cases. She had drug cartel cases. So could it just be a message? Hey, you sent one of ours to prison, or you may be sending one of ours to prison. Therefore, anyone open the door to your house, they're toast. And it's just sad.
It could be all those things. And by the way, we won't hurt you. We'll hurt what you love. That certainly is
right.
a thought process with lots of these demented individuals. We got to switch gears here. Portland, Oregon. There is a video of showing a federal officer hitting a man in a Navy sweatshirt and arresting another. You got to take a look at this.
What are you doing? Use your words. What are you doing? Use your words. What are you doing?
I haven't done anything wrong.
Use your words.
What's going on, sir?
What is going on?
We need to know.
Who are you?
Why are you taking?
NLG will get you out. What's your name? Tell us your name.
What's your name?
Okay, you're fine. We'll get you out.
Bro, what?
We got you, friend.
We got you.
Oh, fuck.
NLG.
You just violated their rights.
Oh. Kidnapping people.
You just violated their rights.
Thanks for keeping the fucking. Oh.
Kirk, as a tactical guy, I mean, this is quite extraordinary to me. These are people that aren't identified, masks on, in military uniforms, snatching a person off the street, throwing them into a van. The young lady is correct when she's saying, who are you? She's like, who are you? And we'll get you out. Get you out of where? Are these really, when this is unfolding, are these the military? Is this the police? Is this some sort of radical, non-authorized group? There's no markings on any of these vehicles. Not to mention, let's just give an honorable mention to the guy wearing the Navy shirt. What an advertisement for Navy, man. That guy could take a lot of hits.
This is amazing, Bob. There's so many problems I have with this. This is not what this country is about. First, starting with the latter, the gentleman in the Navy shirt. If he committed a crime to the point where some law enforcement agency felt they had to use their batons and mace him, then he should have been placed under arrest. If he wasn't placed under arrest, then it's because you didn't believe he committed a crime. Therefore, you do not have the right to use that type of force. There is no middle of the road. The police don't have the latitude to just beat someone down and walk away. So that's one. Well, further, we live in a country where you cannot just be scooped off the street by unnamed or unidentified individuals. If someone came to arrest you just because they had the words police written across their shirt and they were wearing fatigues, does that mean that person is actually a law enforcement officer? How would you possibly know? We don't do that in this country. Our law enforcement officers are identified, and we inform the public, family members, and so forth, where that person is going to be detained, what they're being charged with. So who knows what agency this was and why? I would think whoever it is, whatever agency, they will have a massive lawsuit on their hands for these are clear, for me, civil rights violations.
Linda, we have history to go back on. I'm sorry to say, we live in a democracy. We live in a republic. I can tell you as prosecutor, whenever we had to take a tactical operation, we were very sensitive to not over-militarize, if you will. And there's been a big debate going on in this country for at least a decade or more about how we're militarizing the police more and more. This goes even way beyond even that. Unidentified, masked people, unmarked vehicles, throwing them in vans, assuming that they are a legitimate federal authority. What plan of execution did they have? What orders were they given? This kind of militarization, people don't understand. This is how democracies become autocracies and dictatorships in our history's past. Thoughts?
And this is what happened and I'm going to say now, Nazi Germany, okay, where people were taken off the street where people were beaten, where people just disappeared. And think about this. We just lost the great civil rights leader, John Lewis, right? He had his skull fractured in a peaceful protest trying to get voting rights way back when. And now we're seeing kind of the same thing happening here, right? This man, Chris David, 53 years old, the 1972 graduate of the Naval Academy, he had his fingers broken, I believe maybe possible wrists. Of course, it still didn't stop him from giving these people the finger, which may have been like the minor part of this case. But this should not be happening. We don't even know if these people are mercenaries. We have no idea. Just because they say police, think about the last case with Judge Salas, just because it said FedEx. Are we assuming that was a FedEx person? Just because they have something here that says police, we can't assume they really are the police. We don't know who they are.
Yeah, and to the point of getting back to where these dictatorships and autocracies are created, this is why even in the law enforcement world, we are so sensitive, right, Kirk, to ensure that we're using reasonable display of force and that listen, I know there's problems and there needs to be reform, but it's to avoid this very thing where it kind of reminds me of that quatrain, if you will. You never worried about it. You never worried about it till they came for you.
Absolutely. Police departments, and like you said, there are a lot of issues going on with policing and so forth. But broadly speaking, police departments take great pains to announce who they are, their clothing, attire, no matter, even if they're taking some type of intense assault enforcement action, doesn't just say police. It will say the New York City Police Department and what unit and so forth. And their vehicles are marked. As a matter of fact, there are certain jurisdictions here in New York, for instance, unmarked cars no longer pull people over on our highways because of the fear that folks felt that they were going to be attacked or robbed or whatever the case. They didn't know that they were the police. So the country has moved forward way past. Here's a photo of police officers with their shield numbers on their helmets. We have moved far past this secret police operating under the cover of darkness with hoods on and masks, jumping out and arresting people. This is not the direction that law enforcement should be going in.
Yeah, we've spent many hours here at the Law and Crime Network going over police reform and the ideas of transparency. This is the anti-transparency movement. It's a dangerous one, and all Americans, regardless of your political party, should be concerned with this kind of action. We've got to go to break. We'll be right back. Well, welcome back to our new show, Law and Crime Report. I apologize, my audio is off a little bit today, but we got great guests and great topics, so we are going to move along. This is the Ahmad Aubry case. If you remember this case, this is where the young man was chased down by 3 people and then was shot and killed. Those 3 individuals have pled not guilty. There is a federal investigation in the case, and the prosecutor in the case, Jesse Evans, had made an announcement that there's also going to be additional sex crimes charges against William Bryant, one of the co-defendants in the case. Let's take a listen.
In the transcript, defendant did not call 911 as he began this chase. He also says, or claims, page 31 to 32, quote, he didn't really know each other. Nonetheless, after he and his co-defendants were arrested, they had contact with each other. And that was testified to in states 22 and 255. It's confirmed in captured call detail 6A, which shows the McMichaels having attempted contact with this defendant after this murder, and despite his claim that they didn't really know each other. One of the co-defendants actually refers to the defendant as an ally in a recorded jail call. That's on page 66 to 67, which goes again to the obstruction factor I would submit to the court. As indicted, he's facing not just 18 months that speculatively he might be held upon prior to trial. By my calculations, he's facing potentially life without the possibility of parole, plus at least 27 and a half years. That's a significant amount of time and the most serious charge that can be levied against the defendant in the state of Georgia. There are texts to support the DOJ's investigation. I've revealed this to Mr. Goff, and he knows that we talked about it on the phone. I can confirm as of yesterday that the GBI has opened an additional parallel investigation into sex crimes.
Okay, so there was the prosecutor listing out a number of things. Linda, I want to go to you first. Talk to our audience about the interplay of federal charges that can be filed in a case like this. The state has murder charges, but the federal government also has, in addition to murder in certain instances, civil rights violations. You may remember that case in Jersey where I think the cop's name was Joyce Carnegie, who was shot and killed. Those police officers who were involved in that were brought up on civil rights violations and spent a significant period of time in jail. Where do you think they're going with this, feds versus state?
Well, obviously, the state deals with the felony murder case and the imprisonment case. And we've seen that interplay, by the way, in the Oklahoma bombing. That's a pretty drastic example where you had both state charges, but the feds went first. Here, the federal government can file civil rights cases. And the federal government doesn't have to prove it's based on race. They don't have to prove that Ahmad Aubry was shot because of his race. They just have to prove that his civil rights were violated. That is, he was detained improperly. He wasn't allowed to move from one spot to another. He was attacked because he was in a neighborhood that they didn't think he was supposed to be. So it actually is a pretty easy charge because it doesn't have anything to do with race. It becomes almost like a felony murder charge where you prove some type of underlying felony and also get the murder. So the feds are pretty good here, especially with someone I'd like to talk about after, the defense attorney, Mr. Goff.
What about?
Well, he starts the hearing on the other day dealing with a mask issue. I'm just pulling out my mask because I keep it with me, saying that this is a political prosecution or we have to wear masks because of political. He then goes on to complain that that Roddy is not used to being kept in jail and therefore he should be out. He complained about the victim's attorney being in the courtroom wearing a mask that said George Floyd on it. He complained about everything except for his client. What he should be doing is saying, look, this is the important things about my client. He has ties in the community. He's never committed a crime, X, Y, and Z, go on and on. But he made this grandiose statement. It's like attorneys, Bob, I always say, they start getting into a conflict of interest with their client. It's so important for them to make these statements in court that they forget to have a client that they're representing, and they should be focusing on that client.
Professor, I want to go directly to you. Any thoughts about what Linda said?
Oh, Linda is spot on. This attorney has not done his client justice by his client since the very beginning, since before he was arrested, by putting him on TV and CNN and so forth, not keeping his mouth closed. You serve your client best in many instances by not trying the case in the court of public opinion and staying out of the spotlight. In view of the crime here and the publicity surrounding the crime and the death of this poor young man, the best thing this attorney could do is keep his mouth shut, focus on the bail hearing that was before him, all those other issues, and stay away from all these political statements like the mask and so forth and so on. It is not helping his client in any least.
Agreed. I can't say it anymore. 99% of the times, it does not help the defendant, but some of these defense lawyers can't help themselves when the camera is on. Anyway, when you do stuff like that, you get stuff in return, which you give it that gets taken away. Wanda Cooper Jones is the victim's mother, and she's got something to say.
William Bobby Bryant conspired with 2 other men to kill my youngest son. I named him Ahmad Aubry. I raised Ahmad on my own in this small community of Brunswick. Ahmad was loving. Ahmad worked extremely hard to provide income for our household. Also, Ahmad also worked hard to be physically fit. Mr. Bryant does not deny getting into his pickup truck and chasing my son. He does not deny blocking his pathway. He does not deny recording the murder of my son. He does not deny being within feet of his co-conspirators as my son was called a racist name as he laid on the ground before passing away. He does not think there's anything wrong with what he did. He wants this court to allow him to go home. I often visit the location where my son was killed. And each time I visit there, I fear running into either 3 of the men that murdered my son. because William Bryant does not feel he did anything wrong, what is it to say to stop him from doing this again? He must remain in custody. He's dangerous, he's unapologetic, and therefore I'm asking this court to keep him behind bars.
Linda, I want to go to a legal topic with you first. What Mom was talking about there, very dispassionately,
Right.
very organized, is saying don't release these on bail. Our bail laws are changing all around this country. It used to be just to ensure that a person wasn't a flight risk, but more and more, and I don't know about the state in particular, you are allowed to look at the danger of the defendant and what they pose. So do you find that her allocution to the court was compelling with regard to saying these individuals should not be released for the reasons she stated?
Well, she's giving the reasons why he could be a danger, Bob. But there was a bingo card and somebody won it in the courtroom when the government announced that, indeed, in the courtroom, that there was going to be an open sex crimes investigation. Now, if you want to talk about somebody being dangerous, not only do you have a felony murder charge, but hey, Judge, guess what? We're going to have an open sex crimes investigation against Roddy, William Bryant. And therefore, the work was kind of done before she was able to give that allocution to the judge as to why no bail should be given, because that was, as I said, a bingo card win.
Yeah, Kirk, from what we gather from the news reports, and boy, I wish I could go back to the office when I used to have the real file in front of me and see it all. This came as a result of some data that may have been extracted from his phone. That is Mr. Bryant's phone with respect to this particular additional investigation. And wow, how many times, Kirk, have we been in investigations where we were in spot A and then we got electronic data or other information that led us to other crimes?
Unbelievable. And especially when you talk about cell phones and the cell phone that was used to videotape this incident, that tends to reek of one of two things, either sex trafficking or some type of perhaps underage pornography, right? So what type of data might someone have on their phone that would make them liable for an investigation or arrest and for a particular sex crime? And just turning back the dial just a bit, I want to talk a little bit about strategy. Was there any possibility that this gentleman was going to be released on bail? Some fights are not worth fighting because as a result, now look at all the evidence that has been that's out there for the potential jury pool, the sex crimes, the mother talking about her loss and so forth. So, this was just a lose, lose, lose for the defendant. And perhaps it might have been a better strategy for them to waive the bail hearing altogether.
Okay, excellent. We've got so much more on our plate here on our new show, Law and Crime Report. I'm so happy to be the first guy hosting it, even though my audio is not working so well. But on the other end of this break, the never-ending, unbelievable saga of the Robert Durst matter and his trial. You got to listen to this. We'll be right back. Welcome back. I'm your host, Bob Bianchi. We have breaking news in a case we were discussing earlier today. The case where the judge's son was murdered and her husband was shot and is in critical condition. We are learning from ABC and NBC news sources that there was a suspect, and the suspect has been dead from allegedly, supposedly, a self-inflicted gunshot wound in the Catskills. We talked about this earlier, Kirk, Professor, your experience, and Linda as well. There's going to be no stone unturned, but it seemed like they had a suspect very quickly.
Yeah, so it appears that the suspect was discovered dead in his car by a municipal employee, and there was also a package in the car, the news is reporting, a FedEx package that was addressed to the judge. So there's a lot more to this. And like you said, we knew that it would appear that in some way, shape, or form, law enforcement was hot on his trail. However, this package addressed to the judge, was that a ruse to get at someone else in the home, or was that the purpose of the visit there to actually attack the judge? So I think the investigation is still very far from over. They're going to look into this man's life and his social media presence and everything else, try to determine who he was and why this occurred.
Yeah, well, many people may be
And,
happy.
and Bob, can I just say something? In the Catskills, that's where I am.
Well, there you go, Linda. And while law enforcement may be, happy that the case potentially is solved, what you do lose is the potential of other co-defendants, co-cooperators, especially if this is something with the judge's name on that box. And Linda, I would imagine that law enforcement authorities are treating that box very delicately to see whether there's any detonating devices inside. What do you think?
I'm sure they are, Bob, but the ABC is reporting that the suspect is a lawyer, and they believe now that maybe the husband, Mark Anderley, was actually the intended target. So this is going to be very interesting, but you're absolutely right. That whole car is going to be treated as a possible bomb that's in it, quite frankly.
Well, I mean, I'm not even getting that your guys are looking at, I know on some social media platforms out there, but it's like we talked about before. It could be something with the husband as well. When you do this kind of work, whether you're a judge or a prosecutor or a defense lawyer, there he is, Mark. I worked with him for years at the Essex County Prosecutor's Office. He's put a lot of high-profile murder defendants in jail, but this is supposedly a lawyer, potentially. Look, there's a lot more going to go on. Potentially, we've got to get all the facts, of course, but it's great that law enforcement is making strides. But you can be assured, folks, excuse me, that this case will not end here and this investigation will be ongoing. All right, let's switch gears a little bit back to the Robert Durst case. We all know this billionaire real estate guy, tortured, he kind of wacky dude, tortured history. Many years people were investigating him for the death of his wife. He was involved in another case where I believe an individual by the name of Mr. Black, I could be wrong, he wound up involved in an altercation with that guy, and he went on trial for murder for that, but he got off. And then supposedly the DA's office was reinvestigating the wife's murder, and Durst became concerned that his longtime friend and associate was going to rat on him or give information, and then she winds up dead, and that is why he went on trial. They did opening statements and a couple of witnesses, but had to stop the trial because of COVID-19. So let's listen to a little bit of what the prosecutor is saying, because there's a dispute going on in court right now. Should they continue with the same jury months and months and months later, or the defense who wants a mistrial so they can start the trial again? Let's take a look.
So our proposal would be that we put this case over until April. I think that probably, from what I read at least, that should be after the flu season. Tell the jurors to come back on that date. The court will periodically advise them. But we keep the same jury and we pick up right where we left off. Now, if, when we restart, the defense wants to either re-show opening statements, which were videotaped, they want us to redo the opening statements, we can certainly talk about it. My position would be, Your Honor, that the fairest and most equitable way to do things is, if the jury and the court decides, you know what, we need to redo the opening statements, we play them on the machine just as we are playing half the testimony of this case. And we go from that point. Now, if the defense is sincere in their issue that this is about COVID-19, then they should jump at this proposal that I'm making right now. This allows them to be safe, it allows their client to be safe, etc. If the response is, well, we can't do that, we're going to be prejudiced, etc., then the court has to kind of look behind and say, you know what, is this really only about COVID? And I want to add something else. I want to make sure, Your Honor, that each of the defense attorneys in this case is going to end up signing a declaration under penalty of perjury that they will not be appearing in a courtroom in any case during the interruption of the trial.
Linda, there are so many interesting permutations to this. My read on this on a very superficial level is the prosecution so far has been very happy with the opening statements, very happy with the witnesses they put on. They don't want to go backwards where those witnesses can be cross-examined. And then there's this whole issue, which is true, like what prejudice could occur during that period of time where jurors could be influenced, read things, in the media, which they're not supposed to do. And yet the defense is saying, look, it's too long. Declare a mistrial and let's just start again. So I'm interested in what you think the tactical decisions that are going on here are.
Well, I think what happened is once the court decided it had to put this off, and really, Bob, they did. I mean, come on. Trials can't go on until August. It's really going to be September and it's going to go back on. Look, next April, is this jury the same jury? No. Will people have possibly been sick? Yes. Well, they have been exposed? Yes. So the defense didn't really need to fight the battle right now. Once they learned that this was going to be adjourned to next April, it'll be a battle they fight next year. And we don't even know whether Bob Durst will be alive next year. I mean, he looks pretty sick to me, doesn't he?
Yeah, well, you know what? As a defense lawyer, I think I would be making the motion just to create a record. And who knows? It's a very novel situation that's out there. Kirk, what do you think the strategy is here? I mean, each side made a concerted effort to say, prosecutors, let's keep it going with the same jury pool. Come back in April. We can redo the opening statements and the witnesses, and the jurors can see that. The defense saying, no, it's too long a period of time to leave people hanging out there. Who knows what prejudice is? You could voir dire those kind of things, but why not just declare a mistrial? The case hasn't really gone on for that long. We start over again. What do you think?
It was very interesting. You know, I was watching the prosecutor's body language, and I felt like he was trying to sell himself on his argument as much as the court to a certain extent. So, you know, and this request that it's a fool's errand to think that the defense attorneys would ever sign a document that they won't appear in court until April. So, the prosecution is making the best argument that it can at this particular point. What would be in their best interest? It would be in their best interest that we just freeze the play in the middle and we resume in April. I think that Linda makes an excellent point. This will not be the same jury in April. They will, this case, you just can't keep juries out there in limbo and come back 1 year later. I think the defense has a strong argument for a mistrial. This is not the same trial that started. Certainly there's an option to perhaps for a bench trial, but as Linda also stated, who says that the defendant is going to live? And I wouldn't be surprised if the defendant does not see the end of this trial at all. So I think both sides are making the arguments that are in their best interest. I think the prosecution's argument may be kind of a non-starter here, though.
Call me a brass tacks guy. I'm telling you, in my mind, the prosecutor thought that they knocked it out of the park so far, and they don't want to revisit that with defense lawyers that'll have transcripts of witnesses for which they can additionally cross-examine. But anyway, let's listen to the defense asking for the mistrial, saying they just don't want a do-over. They don't just want a do-over, which says to me they were worried about the first over. They want a redo over. But yet we have some allegations here that Durst is allegedly heard in a phone jailhouse conversation indicating that's exactly what he wants. Let's take a listen.
And I know the court made the comment about the 3-week delay. Your Honor, at the time, we were going week to week to week. I asked for 3 weeks at that hearing. It's in the transcript. We were all kind of in limbo and not really knowing what was going on. So it's very clear that anything that's happened, even after that hearing, was superseded by the court's own, not you, Your Honor, but the higher court's own decisions about what would happen with trials. Your Honor, we discussed things in voir dire with the jury, like the domestic violence, and Galveston, only because the court had pretrial ruled that that was coming in. So for Mr. Lewin to suggest that we brought it to the jury's attention, of course we did. We had to. We got faced with having to deal with an acquittal in Galveston evidence, all of this stuff about domestic violence, which was exaggerated in the presentation of the witnesses and unnecessary. As Mr. Lewin said, Mr. Durst admitted to domestic violence, but we were stuck with the prejudicial live testimony about domestic violence, and the court remembers we filed necessary motions in limine about both issues. Your Honor, we don't believe that Gray applies. We believe that the older California Supreme Court cases, which have never been reversed, apply.
All right, Linda, what do you make of the argument? And, even though we have a masked judge, the eye rolling and the head bobbing was kind of telling to me.
Yeah, you really could see that the judge was not happy with Mr. Chesnoff's argument, but it was a very good argument, and he made the record. And as you know, Bob, we interviewed David Chesnoff on our special we did, And he's going to make his record. And I believe that if the judge hadn't put this off, they were going to take an appeal on this. But I tell you one thing, maybe he was just eye rolling on Chip Lewis's yellow suit with the yellow tie and the hat. Chip Lewis just needed a better face mask. But there was a lot going on in that courtroom, Bob.
Yeah, and Professor, to the point of making a record, what we mean by that is that a good defense attorney tries to find every single legal issue that you can to throw out there so that it's on the record, so that later on appeal, either that issue or a combination of issues, appellate courts have said in its totality make us feel uncomfortable about the fairness of the trial, and it has led, not often, but at times it does, to a reversal of conviction. So that's the defense lawyer's obligation, to raise those issues, fight them, put them on the record, even if the judge rules against them.
Absolutely. So for our lay viewers out there, on appeals are based on matters of law, not so much that the jury got it wrong, but that the court got it wrong, that there was a legal issue and that the court did not reach the proper conclusion on that issue. So as you said, Bob, as a defense attorney, it's your job to put these things on the record, because after all, if they're not on the record, they're not preserved on the record, then your client has no basis for appeal. So certainly you're going to put all these things on the record, and should you lose the case, you will review the record, and that's the basis for the appeal or appeals that you will make down the road. So the defense attorney here is doing his job.
Excellent. Excellent. Listen, this is the inaugural round of the Law and Crime Report, our first episode, our first show. We really appreciate our audience listening to it. We're going to take a quick break, and we got more for you. We'll be right back. All right, welcome back to our first inaugural episode of the Law and Crime Network Law and Crime Report. Got some awesome guests. We're going to take a little bit of a twist on a theme here. Timothy Coggins, back in 1983, was brutally murdered, and it was a cold case for a really, really long time. And there was all sorts of suspicion of, if you guys ever want to, go to the Law and Crime Network, read about this case, how twisted it was. There's a lot about racism. There's a lot about potential Klan involvement. But it wasn't until years and years later that the case ultimately came down to some great investigative techniques, ultimately leading to the charging of two men. Bill Moore was one of those individuals who had pled guilty, and Frank Gephardt went to trial, was found guilty, given a life sentence, and denied his motion for a new trial after the conviction. Let's listen to how we went from a cold case to a hot case. This is the prosecutor in the rebuttal argument.
It's no wonder that the sentiment was that all Timothy Coggins was another dead black man. Because he was. He was. This was just another dead black man until this agent, this captain, the GBI, and the Spalding County Sheriff's Office got the case and began to right the wrongs. They began to interview witnesses, and they interviewed Christopher Vaughn. Christopher Vaughn, a child molester, a convicted child molester. And Christopher Vaughn tells Agent Coleman and Captain Morris that Franklin Gephardt, Bill Moore, Mickey Guy, and a black male that he didn't know were arguing on October 7th, 1983, in the early morning hours of Saturday morning or late hours of Friday night. He's about 10 years old at the time. But he remembers it. And a couple of days later, he and Willard Sanders and Charles Carey found the body. And then a couple of weeks later, while at a party at Willard Sanders' house, he hears Frankie Gephardt admit to killing Timothy Coggins. And on numerous occasions, he hears Frankie Gephardt admit to killing that nigger and stabbing him 25 to 30 times. He admits this to Christopher Bone. He admits to throwing the knife into his well and the clothing. Now, how can you believe Christopher Bone? He's a convicted child molester. You can believe him because no one knew at the time that Frankie Gebhardt told Christopher Bone about killing Timothy Coggins. No one knew the number of times that Timothy Coggins had been stabbed. That wasn't released in the media. There's no newspaper articles about that, ladies and gentlemen. That's a detail only the killer knows. At the crime scene, the body of Timothy Coggins was missing shoes, shirt, and socks.
All right, let's break this down a little bit. So supposedly the victim in the case is a black man, and he was either dating or having a relationship with a white woman. There was an argument back down in that day. There was actually a cop that drove him to this bar who said, you know, you're playing with fire in this county. This isn't like Atlanta. You know, people don't take to that too much. So that was part of one of the motives in the case. So it had gone cold for a long period of time, but that well is really important. Professor, I want to get to that well. Years and years later, where they wound up retrieving stuff from the well when they got information, including the stuff that was missing, but especially the shirt, which had a corresponding number of stab wounds. Very powerful evidence.
Amazingly powerful evidence. And Bob, broadly speaking, this is what it looks like when law enforcement gets it right. And we've seen the Georgia Bureau of Investigation involved in numerous investigations over the course of high-profile investigations over the course of the last 6 months or so. And you know, this young man's death would have never been brought to justice, but for these folks and the doggedness of those investigators involved, and being able to connect the dots with all that damning information. It was just a case that was really handled well. It was executed well. This is what the police do. It's what the police can do. And it's important that we remember that the police operate in this fashion more often than not. There's a lot, we have a long way to go, but this was justice served here, without a doubt.
Yeah, and let's remember that back in the day, there were allegations that the sheriff at the time and their allegations basically quashed the investigation and didn't really move forward with it. That is at least what one side of this argument is saying. Linda, talk to me about what the prosecutor was doing there. I've been there myself. I'm sure you've been there yourself as a prosecutor. You know, a lot of times you got to put nefarious characters and people with convictions on the witness stand, and you're always concerned because the defense is allowed to cross-examine and allowed to be able to say that they're not worthy of credibility because they've committed crimes. There's actual evidence rule that allows that to happen. And so he's kind of vouching for them, if you will, by this independent evidence. And I think that that was key. So what do you think about that as a prosecutor and as a defense lawyer? Tell us about how you go about attacking those witnesses that the prosecution brings on that have prior convictions.
Well, let's remember, Bob, this was a case back from 1983, and a prosecutor in any case, whether it be a cold case or not, really can't vouch for the credibility of the witnesses themselves. But what they can say is that the witnesses are credible because the evidence supports what the witnesses say. And let's face it, if you have somebody robbing a bank or killing somebody, they're hanging around with other people of the like generally. They're not hanging around going to church on Sunday or going to Sunday school. So you have to use people who have knowledge of what the defendant did. And if there's independent evidence that supports it, that's the best thing that you could ever have. So if you're a defense attorney, of course you're going to say, hey, look, he's just saving himself. He's getting some kind of deal. But here that wasn't the case, right? So it was the best thing for the prosecutor. And even though this was an old case, it was supported by people that came forward, wanted to see justice done now. And also you had the DNA, if you recall.
Yes. So obviously very powerful things. I mean, so many cases, you bring that DNA up point, Linda. We did not have access to that when I started trying murder cases. And a lot of defense lawyers want those cases revisited with those DNA and unfortunately get pushback a lot of time by prosecutors. Guys, listen, I couldn't have a better crew here for our inaugural session here of Law and Crime Report, Monday through Friday, starting at 12 o'clock. I'll be back next Thursday. Have a great week. Bye.